Okay, welcome to another episode of Lawyers and Friends. I'm Paul Kornacki, and with me today is my colleague Melanie Daly.
Hi, everybody.
Glad you're all with us. And today we're going to be talking about permanent total disability versus total industrial disability. And this is meant to be an introduction to the topics, and not a full comprehensive study. Where all of us are familiar with permanent partial disability. It's something that we see almost every single day. Permanent total is something that's less common, but we do see it often enough. And then total industrial disability is even quite rare, and we see very few of those cases. So I think we'll start at the beginning. And Melanie, if you feel ready to chime in at any point in time,
I will.
Thank you. Let's start with the most basic, and this is section 15.1. Which provides, I guess we would call this more of a definition of a statutory permanent total disability. Section 15.1 provides that in the case of the loss of both hands or both arms, both feet, both legs or both eyes, or any two thereof, constitutes a permanent total disability. And there is a caveat to that, though, which indicates in the absence of conclusive proof to the contrary, which I can't imagine what other kind of proof you could possibly present in defense of that. These instances, I guess, would describe permanent total at its most basic. This is like the full disaster for all parties. It's much more, the statute goes on to say that in all other cases, a permanent total shall be determined in accordance with the facts of the case, which is like about probably 99% of the permanent total cases that we'll be seeing. Medical evidence for permanent total does not take into account consideration of the claimant's vocational factors. A permanent total case, it's just medical evidence only, as obviously the claimant will be presenting evidence from his treating physician that he's totally disabled, that he's not going to improve, and that his condition is permanent without possibility of any further improvement.
I have noticed during depositions, no, that's okay. During depositions, sometimes treating doctors try to include factors that are not medically pertinent to the case at bay, and they're always trying to say, they try to include vocational factors or comorbidities that don't have anything to do with this claim. So it's pretty important that when you are deposing a doctor that you make sure that they're sticking to the work-related injury only, because the vocational factors should come later. So there is actually a case that says that it's inappropriate for the treating doctor to include any consideration of vocational factors in this medical opinion, but they try to do that. So just something that we look out for.
Thank you, Melanie. And regarding the board requires, for permanent total, the board requires it's persuasive and credible medical evidence that the claimant is totally disabled and unable to engage in any gainful employment, which is quite a high bar. Moving on to the next slide. Some examples. Melanie, could you go through this one, please?
Oh, sure. Yes. This is actually a thank you to Brian Prince for a blog post that he wrote a while back. And he actually, I unluck happened to find it. So thank you, Brian. But in this in this claim, it was established for the back and for hernia, and he was having bladder urinary incontinence, along with consequential bilateral wrist and hand injuries. The doctor was most credible because he saw the claimant in the context of all the injuries related to the claim, and that there was the credible medical evidence of total disability. So, likewise, like Paul was just saying, they don't have to go on to consider the vocational factors when there is the medical evidence of the total disability, which I do notice that the claimant's attorneys always try to go for. And that's basically what their first shot at the chance of lifetime awards starts with that deposition. So they're trying to get the total medical opinion, so then they don't even have to get into the vocational factors.
And as Melanie was saying, finding a permanent total is, it has to be exclusive to those, to the injury sites that have been established. And as she was indicating, it's common that claimant counsel will always try to introduce other factors. But in the case of permanent total, it's limited to just the established injury sites. And I'm going to move to the next slide. Permanent total, earliest example. And I do want to just point out just a typographical error in this. I believe this would be 1915. And this would be a case of Schwab versus Emporium Forestry, where the employee had already lost a left hand unrelated to employment, and then subsequently lost his other hand in the course of his employment, and there was a finding by the board of a permanent total disability. And this evidently this injury occurred just 6 days after the New York State workers' compensation law was enacted.
Yes, I found it very interesting. It has to be probably the first of its kind at that time.
Yeah, at this time, that wouldn't cut it. His unrelated loss of his other hand that would not be considered as part of the permanent total. But back in 1915, it was.
And I think, I mean, obviously it's the date, but I'll have to look back to it. But I think he only got like $5,000 or $6,000 or something at that time. Just interesting.
Yeah, a different time, and I bet the loss of hands in that kind of business was probably common.
Right.
And then just briefly, then we're going to just sort of go back in time a little bit to 2007, when there was the comprehensive reform of the workers' compensation law. Prior to 2007, claimants who were classified with a permanent partial disability could be receiving those benefits. I mean, they're eligible for those benefits indefinitely, and it could be for life. In 2007, there were reforms were made, and now permanent partial disability is capped at a maximum number of weeks. That does not apply, though, in cases of permanent total disability. And Melanie, is there anything else we can add to this particular slide?
No, just that as we've seen, this is a little off topic, but next month, I know James and Melissa will be talking about the temporary caps and how a recent third department decision also kind of found a way for claimants to circumvent the caps, because once they have a causally related surgery and they are found to be temporary totally disabled, then they would have to be reclassified. And that's kind of an issue that we saw recently. And so even though they did, put the caps on it, there are still ways that they can circumvent them, which is, not good for carriers. But I'm just also wanted to point out that I find it surprising that temporary industrial or total industrial disability is actually as rare as it is. I feel like that would be something that they would pursue more, but.
And we're going to get to total industrial disability in a second, but I often wonder why. I wonder why more cases are not brought under the theory of total industrial disability, but we just don't see it that often. But for some reason, that's the claimant's counsel maybe just don't want to bring it, or they don't want to go through the extra step once the claimant's already been classified with a permanent partial disability. Anyway, we'll get to that in 1 second. Just also briefly, just regarding the safety net. This is under section 35, and this was actually a discussion from a prior Lawyers and Friends, but the board did put in a safety net under section 35, which means when the cap is coming to a close, the claimants can ask for reconsideration or an extension with an indication that they are having it's a hardship. Melanie, can you help me out on this a little bit?
Yeah. Well, basically, there was a case which was surprising that even if the caps have already run out, they are not precluded from raising total industrial disability. I think there was a case, I don't know if it's in the next one, but it, first of all, the law judge found that he did not meet the requirements for total industrial disability, but then the board reversed it. And then the third department reversed the board's decision, finding that he was not precluded and it should go back. So basically the board kind of didn't even take the issue at hand and just said he's not precluded. So I guess they don't have to, I don't know how much time they have beyond the running out of the caps, but you would think that they should at least be required to do it by the end of their caps. I mean, because, if they're really trying to make an effort to seek employment while they're having the partial disability, they wouldn't realize that at the end of the caps. They should realize that right away, theoretically. But
right, the caps are put in place for a reason. It was part of a total reform package. Carriers gave up attachment issues in exchange for having permanent partial disability cases capped at a certain amount. Going to the next slide, total industrial disability. And as stated, to prove a claim for total industrial disability, permanent partially disabled claimant must demonstrate how the disability combines with other factors to render the claimant incapable of salaried employment. And that's the Guan case, and I've often wondered why they chose the word salaried. It seems an unfortunate choice, but I understand what they mean. But anyways, the first step in claiming total industrial disability, the first prerequisite is that the claimant has been found to have a permanent partial disability. So step one, permanent partial disability, and then the claimant has to come forward later with some additional evidence indicating that his disability, in fact, he has a total industrial disability under the framework that we're going to see in a minute. There are certain factors to be considered in a claim for total industrial disability. Well, the first step, as we said, there has to be a finding that the claimant has a finding of a permanent partial disability. And then the claimant has to go on to show with his evidence or her evidence to demonstrate how that permanent partial disability combines with other factors to render the claimant incapable of salaried employment as set forth in that case. Melanie, can you tell me a little bit about the 75% that you put into this slide?
Yeah, if they are the March permanent partially disabled. That's what I gather, that they would have to be
Trying to find.
medically, at least from our disability. And then they consider the factors in combination with that.
Okay.
Yeah, I think they could bring a claim for total industrial even with less with any really degree of permanent partial disability. I would think it would be largely unsuccessful. I would think you would have to have at least a high permanent partial disability to have any hope of achieving a total industrial disability. But once the claim is put forward for total industrial disability, the board will consider certain factors, and that would include the claimant's limited educational background, its functional limitations, its age, her language proficiency, and any kind of work experience that the claimant may or may not have had.
How do I do this?
I do notice that all the claims or the cases that I did see, it seems like the language barrier is the biggest one that is most likely going to find a total industrial disability. A lot of times
And also, the claimant may have been classified with a permanent partial disability 5 or 6 years earlier. So yeah, their age is going to change. They may have chronic conditions which just progressively grow worse over time, and their overall condition may change to the point where that they have a claim for total industrial disability. And this is a summary of that Guan case. Claimant was born in 1952, moved from China to the United States, became a home health aide. Based on the claimant's lack of English and language proficiency, advancing age, limited education and training, impaired manual dexterity, reduced physical stamina, and limited attention span, she was considered unemployable, and the board sustained the finding of a total industrial disability.
Just to go back to the 75%, I think I added a portion from the extreme hardship. So that's a different thing. It's not required for the total industrial. So just wanted to clarify that before we move forward.
Now, I suppose in discussing the evidence that supports the claim for total industrial disability, there are a number of, the case law has consistently set forth a certain number of factors that the board will consider in a claim for total industrial disability. First of all, the claimant's testimony on his or her functional limitations, limited education, etc. So basically, the claimant's going to have to testify with respect to his or her current condition, and that certainly opens that person up to cross-examination. Another factor that the board will consider from the claimant are any efforts to secure employment. And I think this is probably one of the main reasons why we don't see total industrials, because claimants, one of the factors worth consideration is whether or not have they looked for work and been unsuccessful in that process. Now, a claimant doesn't have to show, you do not have to show attachment to the labor market, because after all, he's already been classified with the PPD. But a claimant can come forward with evidence that he or she was unsuccessful in attempting to secure employment with their permanent partial disability. And of course, that will certainly open that person up under cross-examination as to how serious or how much effort was actually put into a job search or a work search to find some kind of part-time, light duty or work that would match their restrictions.
And I can imagine with the, I'm sorry to interrupt, the pandemic, that a lot of people are working from home and some businesses are keeping people remote. So I imagine that would eventually become harder for claimants to prove that they're, I mean, if you're at home anyway and you don't have to do anything, I mean, you know, to apply to a remote job would something that a claimant should be able to do and obtain.
And I do want to say also at this point that we have seen situations where a claimant comes forward with a case seeking a permanent total disability, but then claimant's counsel will say, well, in the alternative, if my person is not at permanent total, then there should be a finding of a total industrial disability. So, and as we have discussed in the past amongst on our Friday morning meetings, that it seems it's really inconsistent to make a claim for permanent total disability and at the same time make a claim for total industrial disability, only because if you're acknowledging that the person has a total industrial disability, you're admitting that they have some working capacity. So typically then, the way it should work is that if a person makes a claim for permanent total disability and then fails in that effort, he'd be found to have a permanent partial disability, and the caps would begin to run at that point in time. But as we shall see in one of the upcoming slides here, that the board can make a finding if a person fails in their effort for a permanent total disability, that the board can make a finding of a permanent partial disability and go on to find that the person is also has a total industrial disability based on the facts submitted. The medical evidence that we were discussing, the medical evidence in the case of total industrial disability, there needs to be the claimant has to produce something, some medical evidence showing that he or she is functionally incapable of working. So I guess that sort of brings the question of whether or not there will be new medical evidence introduced at that point in time. And that also raises the question of, in a claim for total industrial disability, is a carrier allowed to produce an IME, which would show essentially no change from when that person was classified with a permanent partial disability. But certainly, if new evidence is introduced, that showing that by the claimant showing that he or she is functionally incapable of working, that would be open to cross-examination. In addition, the claimant, as part of the claim for total industrial, they can produce a report from a vocational rehabilitation counselor demonstrating that the claimant's essential, unsuitability for general employment. And I have seen these reports from vocational counselors indicating that the claimant has no ability to be retrained and has no possibility of seeking any kind of gainful employment. Certainly, any report from a vocational expert like this would be subject to cross-examination, and you would certainly definitely want to arrange cross-examination of these experts, as oftentimes they have very limited understanding of the claimant's actual medical condition. Also, I wanted to indicate that just regarding when the claimants submit this work search as part of this effort for total industrial, they don't. If they submit, they really need to submit a bona fide work search showing that they made an actual effort to secure to to become like reattached. It's not a requirement though. The board does not require claimants to produce this kind of work search. But without such a work search, I can't see how you can possibly bring a claim for total industrial disability. You have to bring a bona fide, a valid, comprehensive search in order to just to bolster the claim. But again, this would be subject to cross-examination as to what those efforts actually were. Melanie, anything else on the evidence regarding total industrial disability?
Nope, I think you covered it.
Regarding the, of course, the burden of proof never shifts really from the claimant in a claim for total industrial disability. They have to provide a claimant with a permanent partial disability must provide sufficient evidence that he or she, again, this is another phrase, is functionally incapable of working due to both the causally related and unrelated injuries or conditions. And that was the case of door-to-door ambulance services. A finding of total industrial disability is supported by evidence that a permanently partially disabled claimant is incapable of gainful employment.
The door-to-door claim, that was, the law judge did find him to have a total industrial disability. And then the board reversed it, finding that it was not sufficient. And then the third department actually reversed it, or the full board panel reversed theirs. So it was kind of a back and forth, which is interesting. Just basically, this is another one that I believe English was not his first language, and the full board panel said that they'll, they give deference to the board. This first decision reversing it didn't match the facts of the case or the law, so.
And the board will uphold a finding of total industrial disability where there's this combination of elements that we just discussed to show that the claimant is incapable of engaging in any sedentary employment or is incapable of sedentary employment or engaging in any meaningful vocational rehabilitation. In cases like that, the board will uphold the finding of a total industrial disability. Is there a time bar to bring a claim for total industrial disability? Certainly in cases where the claimant has classified with a permanent partial disability, there's a cap and there's a time frame. Melanie, can you tell us a little bit about this case?
Yes, this is I did cover it earlier, but the case where the law judge found that I forget exactly how it went, but basically the third department found that he was not precluded from raising it even though the caps had ended. So based on the plain language and the whole point of the total industrial disability, which was basically to give the claimants a safety net, they would not preclude a claimant from bringing up the total industrial disability if the caps had run out. So it doesn't really indicate how much longer after. I'm assuming obviously there has to be some time bar, but again, it's just kind of, claimant friendly. They can raise it even if it's already expired, even if it's kind of a last minute decision, like, what do we do now? So then they can bring it up, which I don't really agree with. I think it should be toward the beginning of their caps to be able to raise that instead of, when they're running out and then they want to make a different decision to keep those awards going.
And this is the interesting case of this Collins Building Services. And this is what we were discussing earlier when in bringing a case or a claim for a permanent total disability, typically if one fails in that effort, the board will find that, okay, the claimant doesn't qualify for permanent total, and therefore he has a permanent partial, and therefore the caps will run. But in this case of this Collins Building Services, the judge, after hearing all the evidence, did find classified the claimant with a permanent total disability. Carrier appealed. The board panel reversed and said that, well, there's insufficient evidence for permanent total. But it then went on to list and discuss all the criteria for total industrial disability. It then went on to classify the claimant with a permanent partial disability, and then found that, based on all the criteria that had been submitted as evidence, the claimant did qualify for a total industrial disability. It's almost like a full reversal of what the judge had found, but the result is the same. I can only imagine Carrier's counsel reading this decision, saying, well, okay, in the first several paragraphs they reversed the permanent total, so that okay, thank God we've overcome that. And however, then in this case goes on for several pages that went on and on as they discussed the criteria for total industrial disability, and then went on to say, well, no, the claimant does not have a permanent total. He has a permanent partial disability. But in addition, we are making the finding that he has a total industrial disability. So the end result is the same. The indemnity benefits are at the total rate, and the case is not capped. Melanie, did you have anything else? Did you know anything else about this case?
No, just like I said before, the language barrier seems to be another one where this is another one where he was born in Ecuador, and if they're not proficient in English, then that seems to be a big factor that can easily find a total industrial disability. And I was reading another claim where she had about 3 months of English lessons, and then she was also found to have total industrial disability. Which I don't know, maybe that could change now. That, I mean, not be such a strong factor now that a lot of things are, you can teach remote, you can teach English as a second language, or you can teach the language. Obviously it depends on our education level, but it just seems like it would be less likely for a total industrial disability based on that, since everyone uses the internet for everything. So there could be opportunities for somebody, even a translator or something, where you just, you have to sit in your house and you can do it remotely.
And I also just wanted to mention briefly that when a claimant is classified with a PPD, in any case where a case is closed with PPD, and then there's an attempt to reopen, obviously there are a number of, if a claimant comes in and says, well, I want to reopen my PPD case because I'm pending total industrial, there are certain requirements for the board to approve a reopening of that case. So a claimant's going to have to come forward, in the RFA with some new evidence or some evidence of total industrial disability, and likely that would have to include, he would have to present his job search with the RFA, or with a report from a counselor, a vocational counselor, saying that this person has no ability to be rehabilitated and no ability to find, general employment. So in order to get their foot in the door for a claim for total industrial disability, the claimant's going to have to reveal some evidence right out of the gate in order to get that first hearing on the issue. So, and that would give us, obviously, us some advance notice of where the claimant is going, and an ability to prepare defenses against that. And at this point in time, then, does anyone have any particular questions that we can answer regarding permanent total or total industrial disability?
Yes, Brian has a few that he's in the chat.
I cannot see the chat, but go ahead. What is the question?
Well, the first one is, do you think the legal standard for statutory total disability is lower than a permanent total disability in other contexts?
Well, if we're talking about the loss of extremities, two extremities or loss of vision in both eyes, I think the medical evidence in that case has to be pretty. I think the standard would be lower because the evidence needed to show that would be relatively simple. So yeah, I think the statutory permanent total has a lower bar, but in those cases, it's such a catastrophic accident of losing two extremities or losing vision in both eyes that I think the bar wouldn't naturally be lower. What was Brian's second question?
The second question is, do you think that the claimant's failure to do anything to improve their education skills or training cuts against the claimant seeking to use those things as aggravating factors? I personally probably would say no, because everything is pretty claimant friendly already. And I'm sure it would come to down to the claimant has been unable to work as a result of this injury and is getting, less wages than he was when he was working. So he doesn't have the means to go back to school or improve his skills. But I don't know anything concrete. That's just my opinion. I'm sure that it would probably not help us at all. What do you think, Paul?
Yeah, I don't think that I don't think the board would be asking claimants to show evidence of why haven't you failed to improve your situation.
Great, thank you very much.
Do you want a napkin or anything?
Yeah.
Andrew's lunch is here. Andrew, you're not muted.
I'm sorry.
But anyway, Paul, if you have anything to add to that, but I'm sure as far as how lenient they are on labor market, I'm sure they would not go this extra step.
Yeah, and especially in cases of total industrial disability, when it's not even a requirement for the claimant to show that that I've made this job search. It's not required. He can just skip that part. But if doing so would certainly put your claim in peril. I can't see how permanent partial disability, a person who's classified with a permanent partial disability, can bring a claim for total industrial if you haven't shown that you've made an effort, some kind of effort to look for work. It doesn't have to be comprehensive. He doesn't have to show attachment, but he would certainly have to show that this is what I've done, this is who I've contacted, this is what I've done to rehabilitate myself, and none of it's been successful. Yeah, are there any other questions?
Yes, and he follows up, have you had any luck with vocational assessments in cases with a legitimate total industrial disability claim?
I'm sorry, can you repeat that? I didn't quite.
Yes, have you had any luck or have you had luck with vocational assessments in cases with a legitimate total industrial disability claim?
The only experience I had is just the one time when there was a lengthy statement from a rehabilitation counselor, which stated that the claimant had no ability to be rehabilitated and was incapable of employment. And we did cross-examine that counselor, and it turns out that he had some contact with the claimant, but not a whole lot. He had sort of a very limited understanding of what the medical issues were. And so, just under basic questioning, his report showed some holes in it, and we were able to exploit that. Is there any other questions available?
Yes, this is from Brian also. If you can raise total industrial disability at any time on a long enough timeline, wouldn't everybody be unable to work at some point based on the combination of injury and non-injury factors? Which, yes, that's what I did think about that, because there has to be a timeline after their caps run out that they can't raise it anymore. So I'm not sure exactly what it is, but obviously as people get older, their employability is going to diminish. So I would like to find out how long they can raise it after their caps run out. And Paul, if you have nothing to add to that, there's one more question from Brian also. Is there no interplay between extreme hardship and the ability to reopen the claim to raise total industrial disability?
Yeah, and obviously, regarding extreme hardship, that's not something that I have a lot of familiarity with. I know Brian did a comprehensive talk on that at previous Lawyers and Friends. There's certainly got to be some interplay, though, between extreme hardship and also making a claim for total industrial disability. But I think it's two separate animals. Extreme hardship really is more of a financial analysis of the claimant's condition, whereas total industrial is really looking at possible changes in its physical condition. And total industrial also considers not only the established injury, but other factors and other medical conditions could be taken into account also. I'm surprised James hasn't chimed in with any additional questions or comments, but I hope he's enjoying his vacation today.
Yes, he's eating some crab legs. So I guess my whole take on the total industrial, I'm just surprised it doesn't come up more. It just seems like I've never had one myself. I don't know how many other attorneys in the firm have had them, but it seems like they either go for the permanent total or find some way to extend the caps. But it doesn't seem like I haven't seen it very frequently at all.
And I'm wondering also why. Perhaps it's just when claimants counsel, when they're successful in getting someone with a permanent partial disability, the caps are going to run for a set number of years. There just isn't a financial incentive on their part to press forward and see if they can get a total industrial disability. I don't know why we don't see it more often, but I do think one of the concerns is that claimant's counsel is going to tell their person, you're going to have to show that you've tried to look for work and made some effort on to do that. It's not required as part of the proof, but it's certainly an important consideration. And if you want to make a claim for total industrial, you're going to have to show that you've tried to look for work or rehabilitated yourself. And most claimants, once they've been classified, they just don't want to do that, and they're not going to do it. And that might be one of the reasons why we don't see these very often.
Does anybody have any additional questions or comments? Brian?
Didn't I ask enough?
Yes, I'm kidding.
Well, no, because my thought initially regarding the whole lower standard for statutory total was Forrest Gump and Lieutenant Dan. It's like, Lieutenant Dan, you got no legs, but he could work a shrimp boat. But New York State would say Lieutenant Dan is statutorily totally disabled.
They would. Even though obviously he was not.
So, I mean, yeah, I think you need a much more specific set of circumstances, but I do think it's a lower barrier overall than permanent total from all employment for other things like a back claim.
Yeah. Someone with failed back syndrome is going to have a lot more to prove, and be a much tougher case to prove. But that's what, for some reason, and why does New York State list those extremities, and why is it like a sort of a mix and match, any combination of the two? That's a mystery to me also.
Well, at the same time, if someone got their right arm and their right leg ripped off in the same machine, what, are you gonna say he can hop along and do a one-handed typing job or something? Again, exceedingly rare. So
Exceedingly rare and exceedingly catastrophic at the same time, but that's what we have to work with. Okay, then. If there are no other questions, then I thank you all for being here and for listening to this introduction to permanent total and total industrial disability. Thank you so much, Melanie, for all your help today. We really appreciate it. And everybody have a great weekend.